My name is David A. Kyne, and I live in the Montreal area. Specifically, I live on the West Island of Montreal. I actually don't live on the island of Montreal. I live on Ile-Perrot, in the town of Ile-Perrot, located almost exactly at the confluence of the Ottawa and St. Lawrence rivers. My remarks today are directed primarily to the attention of the General Counsel for McGill University, Madame Line Thibault, as well as to the Legal Counsel of McGill University, Madame Victoria Percival Hilton and Tim Carsley. My remarks are also directed to the attention of Monsieur Spencer Boudreau, who is currently the Ombudsman for McGill University. My remarks concern the disposition within the past 30 days of an application which I presented to the attention of the Admissions Committee of the Faculty of Law of McGill University for admission to their undergraduate program in law, and specifically their combined civil law and common law program, which is a 4-year program within the faculty. As nearly as I can recall, I began to build the online dossier probably around the end of September, and it was complete on the very last day before the application window for that session closed on the evening of the 8th of November. I provided copies of my academic transcripts. I provided letters of reference. I wrote a personal statement. And because I was applying as a special candidate and also possibly as a mature candidate, because I'm obviously a mature student, I included a brief memo or memoir of extenuating circumstances. In general terms, the file was completed in good time, just before the closure of the application window on the 8th of November, and I settled down to wait the decision of the faculty, the admissions committee, with regard to the disposition of my application. And I waited through November, and I waited through December, and I received no notification or any form of update from the faculty or the admissions committee or the university. I waited through January. I believe towards the end of January, not immediately, or possibly early February, I noticed that when I surveyed my dedicated application page, that a modification had been made to the rubric of that page, and that whereas I had applied specifically for admission in the bi-term in January, the winter term, my application now indicated that I was in contention for admission for the autumn term in September. I found this curious. I found it somewhat disturbing, but I really didn't have the time, pardon me, to consider the matter to any great degree, and I consoled myself with the position that whereas I may not have been successful in terms of my application for admission in January, it appeared to me that I remained in contention for admission in September. January went by, February went by, and then finally, within the past 30 days, I received notification on Tuesday, the 26th of March, that my application had been declined. And I was very distressed and upset by this, as I indicated in my memo of response to Professor Martin Alley Mayer, who appears to be the director of the Admissions and Recruitment Committee. And I subsequently contacted the Office of the Legal Counsel, and I received within the past week a response. This time it was an unsigned response, I believe from the admissions committee in general terms of the Faculty of Law. There was no signature, addressing some but not all of my concerns with regard to this matter. I'm distressed by the decision of the faculty, by the admissions committee, for a number of reasons. I'm, first of all, concerned by the length of time that the faculty took to reach a decision with regard to my file. I think that 4 months is far too long. I tend to suspect that my file was held in an suspensive state, otherwise in état suspensif or litis pendens, deliberately in order that I would lose interest in my application, that I would unilaterally terminate my application, and by so doing I would relieve the faculty of the obligation and responsibility of having to make a potentially awkward, difficult, and problematic decision with regard to my file. I'm also concerned because I believe that an unspoken and silent consideration with regard to the admissions committee concerned my age. At present time I'm 51 years of age, so I would qualify as a very mature candidate. And whereas chronology is something over which I have no control, I do believe that the admissions committee considered the matter of my age in negative terms. I tend to suspect that the admissions committee believed or thought that it was possibly a waste of time to offer me admission to the faculty, if that would mean that someone much younger than I, in their late teens, if they were applying from CEGEP in Quebec, or someone in their mid-20s, late 20s, even early or mid-30s from other parts of Canada, who would quantitatively at least have a far more protracted career in the law than myself at the present time. And whereas I do concede that as a consideration, I will state that this does constitute a form of discrimination, which is enjoined by legislation, specifically within Quebec by Article 10 of the Quebec Charter, which forbids discrimination upon the matter of age, as well as an extensive calendar of other categories. And chronology, as I stated, is something over which I have no control. I wish that I had applied earlier. I wish that I had applied 10 years ago. I wish I had applied 20 years ago. But due to various circumstances, I did not do so. I'm also concerned by a statement which was appended to the end of the letter informing me that my application had been declined. A brief reference to an abortive application that I had made and then given up in 2006. In 2006, in fact, I did make an application to McGill and to the Faculty of Law. It was rushed. It was not organized. I had difficulty finding a second reference, and due to this and other circumstances, I was unable to follow through on the application. I didn't make specific reference to this specific application at the time I applied this second time, purely upon the basis of arithmetical terms. 2006 is not recent. It's six and a half, 7, more than 7 years ago. Universities, as public institutions, generally tend to move on a quinquennial time schedule of 5-year plans. So I didn't really believe that my application of 2006 was of any great moment at the present time. So I made no reference to it. I tend to believe that when the admissions committee believed that they really had to make a decision after having kept me waiting for so long, that they figuratively, possibly literally, dug around in my academic background to determine whether I had in fact made an earlier application either to the Faculty of Law or to any other faculty or department within McGill, and to use that as a ex post facto justification for declining my application. The original letter also made reference to the policy of the Admissions and Recruitment Committee, that they use what they term an holistic approach when assessing a candidate's application. And my response to that would be that this is obiter. This is, in vernacular terms, nonsense. This doesn't really convey anything to me at all. It's very empty, it's very vacuous. What does holistic mean? I don't believe that's a valid justification for declining my application. If by the term holistic, the admissions committee in the person of Ali Meyer is intending to convey to me that they look at the entire application or they look at the applicant as a whole person, I don't believe that my application was of any less merit than other applicants with whom I was competing. I am a product of a very unique and unfortunate series of circumstances, and I really don't believe that McGill or any other faculty department or in any other university receive applications from people such as myself very often. So if we do take the term holistic at face value, I don't believe that my application suffered any loss of authority or credibility in comparison to other applicants. I'm also concerned by the fact that my application appears to have been transferred or carried over from the winter term application pool to the autumn term application pool. I'm not sure why that was done. I wasn't notified. I will say that I wasn't seeking admission in the autumn term. I was seeking admission in the winter term. If I wanted to apply for the autumn term, I would have applied for that specific term. And again, I suspect that upon reviewing my application initially, at the end of 2012, that the admissions committee considered my application rather problematic, and that possibly on a personal basis, on a moral basis, they couldn't bring themselves to decline my application because it was so strong and possibly, to use your term, so holistic. And I think that a decision was made that my application would be carried over to the new year in order that it would compete with the much larger application pool of applicants that begins to aggregate after Christmas. And I tend to believe, upon that basis, that it was the intention of the admissions committee, because they could not decline my application qualitatively, or to use your term, holistically, that they were going to subordinate and smother and extinguish my application quantitatively beneath the cascade of applications which the university in general and the Faculty of Law specifically in this instance begins to receive in the new year. And I consider that to be administratively irregular, and I consider that to be administratively and professionally dishonest. If my application was competitive for January admission, and I continue to believe that it was, I ought to have been offered a letter of admission in January. I tend to believe that upon an administrative basis, I and my application have been the victims of what might be termed an abuse of law. I have been the victim of what I might term irregularities with regard to the administrative process. I would like the General Counsel for the University and the Legal Counsel for the University, as well as the Ombudsman, to conduct at their convenience and at their discretion and comprehensive administrative analytical review of my file, as well as the manner per which my file was evaluated and assessed. I will state in addition that consequent to the faculty, pardon me, declining my application and the length of time that it took them to reach that decision, that this has left me in a very unfortunate position. It's currently the end of April, and the application dates for practically every other faculty within Quebec and external to Quebec, with possibly some exceptions, are closed. I'm aware that Moncton, which offer a common law program in French without the LSAT, their application window closed in March, the 1st of March, which is nearly 2 months ago. I think that the UDM application date is 6 or even 8 weeks past the present time, date of the composition of this video. The application window at UQAM is closed. The application window at Sherbrooke is closed. I wouldn't want to go to UQAM anyway because of the neighborhood in which the university is situated. I believe that the civil law section of the University of Ottawa in Ottawa have a relatively late application date, but consequent to the costs of university education having been deregulated in Ontario within the past 10 years, within nearly the past 20 years in fact, it's very expensive to go to school, and it's particularly expensive to follow a course of professional education anywhere in Ontario. I think the costs per year, per annum, in the civil law section are probably $8,000 to $10,000, possibly $12,000 a year. I believe that the common law program is even more expensive for some reason. I believe at the present time it costs about $20,000 to attend the Faculty of Law at Queen's. So this has left me in a very awkward position academically and geostrategically. I'm not in the same position as an individual much younger than myself, in their late teens, early 20s, mid-20s, who has at least one parent and probably two who are still working, who would be capable of funding this individual if that individual wished to travel and apply to a faculty elsewhere in Quebec or elsewhere in Canada, in the United States or overseas, it's become far more problematic for me to translate my domicile to another jurisdiction, even within Quebec, just over the past 10 years. So the decision of the faculty is very unfortunate for me from that respect. And I only applied to McGill, pardon me, because I only wanted to go to McGill. As I stated in my personal statement, I lived very close to McGill for part of my childhood. I lived just 1 or 2 streets over on Mountain Street, and my mother used to take me through for walks through the McGill campus, and we used to visit the Red Path Museum. So for at least part of my childhood, McGill was, one might say, part of my neighborhood. It was part of my daily reality as a child growing up in Montreal in the early 60s. I would like the legal counsel, the general counsel, the ombudsman to consider this issue on my behalf. I would like the decision of the admissions committee to be reviewed. I would like the reasons or the rationalization upon which bases the admissions committee arrived at their decision with regard to my file to be examined closely in terms of its probity, honesty, and validity. I do believe there was an element of bias. I do believe the decision is irregular. I do believe that it's a decision that the admissions committee didn't want to make, and that's why it took them so long to make that decision. And I look forward to further correspondence from the General Counsel, Legal Counsel, and Ombudsman for McGill University with regard to this matter. This video will accompany a written reference composed and written in French to demonstrate my linguistic written ability in both English and French. In terms of what I might say in conclusion, I think that as a candidate, upon an holistic basis, that I could have contributed to both the academic and general life of the faculty in a very real and unique way. I doubt if I am the sort of candidate which McGill University encounters every day, or even from application cycle to application cycle. I think that as a candidate I'm uniquely Canadian, in as much as I was born in Quebec and grew up in Ontario. I was born in Montreal and I grew up in Peterborough, Ontario, which has been characterized and referred to as the epitome of small town Canada. I read my first degree at York, my undergraduate degree. I read my graduate degree at Concordia. And I speak English and French. I speak English, obviously, you can tell, as pertinent to my composition of this video recording. Je parle en français aussi, plutôt bon, je pense. À moi, tous mes amis à français. Oui, monsieur, you speak very good French. Because of my unique circumstances as a child and adolescent, I think that I could have contributed a unique perspective in terms of the criminal law as it applies to children who have been the victims of crime, droit de personne, constitutional law, and the Quebec Charter. I think that I would have positively augmented both the academic as well as the general social environment of both the Faculty of Law, McGill University, as well as McGill University in general terms. And I would like these issues and considerations to be examined. I'd like to thank the General Counsel and the Legal Counsel and the Ombudsman for viewing this video. I'd like them to take a close look at the accompanying written text, and as I stated momentarily, I look forward to hearing further from you with regard to this matter. Thank you very much.